This is our second video for weeks 9 to 10, and we're going to take a look at, first in this video, defenses in negligence cases. One of the things I didn't put in when I spoke about, wrote about defenses in negligence cases would be the simple proposition, if P sues D for negligence, one defense would be on D's part, I wasn't negligent. I talk about two potential defenses, and that was one of them. I don't think I was explicit, and shame on me. But so one defense is D wasn't negligent. Another defense would be the defense of comparative negligence. And this can come up factually in a number of different ways. Let's just take two examples. Example number one is a car crash. And not all vehicular accidents permit this analysis, but some of them do, which is both drivers were negligent. One driver was negligent because that driver didn't look carefully enough before entering the stream of traffic, and the driver that smashed into the car entering the stream of traffic was driving too fast. You could have situations like that. Both, if you will, plaintiff and defendant are negligent. A second example would be a trip and fall or a slip and fall case. And that is there's a slippery object left on the floor of a business. It's been there long enough where the business can be charged with knowledge of it. And a person slips on it and falls and is hurt. There's possibly room to argue that not only was the store owner negligent, but the person who slipped and fell was negligent because they weren't looking to where they were going. And so we can have these factual situations that could permit the conclusion that both the plaintiff and defendant are negligent. Now, back in the 1970s, you don't remember that decade, but I do, there was a significant change in New York. The legislature, if you will, changed the common law rule of contributory negligence. And that was a pretty harsh rule at times. And that rule said that if the plaintiff's negligence contributed at all to the injury-causing event, like the vehicular accident, that the plaintiff got nothing, received nothing. It was a complete defense to the defendant, no matter how much the defendant's negligence may have contributed. So the legislature changed that, and now under comparative negligence, a plaintiff's negligence does not completely bar recovery, but diminishes the amount of damages by the percentage plaintiff's negligence contributed to the harm-causing event. Example, the auto accident. And I give you an example that I don't want to walk through. I think it's pretty obvious. It's basic math, but take a look at this example and you'll get a sense of where we're going with it. Let me just pause. I need to get another screen up. So we've identified two defenses in a negligence case. One, the defendant wasn't negligent, and two, even if the defendant was negligent, the plaintiff was also negligent, and comparative negligence requires a reduction of plaintiff's damages by the percentage that plaintiff's negligence contributed to the injury-causing event. We're now going to talk about another concept, so this is separate and distinct from defenses, and it's called vicarious liability in negligence cases. Vicarious liability is where a person who is not directly involved in the injury-causing event, like the car accident, is going to nevertheless be held liable for it. Those of you who are in my crimes course, this has the flavor of, but it is different than the Section 20 liability under the penal law. Section 20 liability under the penal law, liability for the conduct of another person, requires a specific intent and assistance and so on. The vicarious liability that we're talking about here is really based on public policy considerations to, it would seem to me, make certain, if not make certain, but increase the certainty that somebody with some money in their pockets or insurance in place can be looked to for recovery. Under circumstances where we would think it's fair to hold that person in. And we're going to take a look at two examples of vicarious liability. One is in a car accident, and a second one would be employer-employee. But let's stick with the vehicle first. The owner of a car is vicariously liable for the negligent operation of the car by another person, provided that the other person is driving with the owner's consent. I know in my house there's a couple of cars and a couple of drivers, and the two adults each own their own car, but if the other person's car is at the end of the driveway and somebody needs to go to the store to get milk, certainly that person just takes the keys off of the hook in the kitchen and drives the car. But under those circumstances, that person is driving with the owner's consent, just given the overall setup of where the hooks are, where no one has ever said anything the best, you can't drive my car, or, and so on. That would be one example of vicarious liability. A second example, as I said, is the employer-employee situation, and you're going to have vicarious liability on the part of the employer if the employee is negligent while working within the scope of employment. And certainly if the Amazon truck driver is negligent, then that person's employer, Amazon, would be liable for the negligence. Or, I'm not trying to pick on Amazon, UPS or whatever. FedEx, let's throw them all in. Okay, so that's our sense of vicarious liability. We also have other torts, and I'm going to just talk about two of them. One would be the tort of battery. And we could call this an intentional tort because, unlike negligence, the defendant here intends to engage in the tortious conduct, which is touching the defendant without the plaintiff's consent. The touching often is a violent type of touching, or perhaps a molesting type of touching, which I guess not, that would always be violent too. And we now have the tort of battery. And I just use a basic one. Assume A punches B in the nose, A's conduct. Remember, it can be criminal too. So while obviously constituting criminal assault would also qualify as the tort of battery, and B could recover, presuming A had any money. So attorneys aren't thrilled with intentional torts for the reason is that I can't go out and buy liability insurance, more of that later, but I can't buy liability insurance to protect myself for damage caused by my intentional torts. So a person comes in to our hypothetical law firm for a possible tort claim. We always have to consider where a source of recovery could be had. What I've done, and I know a lot of other lawyers have done, sometimes we've taken that intentional conduct and try to make it reckless, or put an element of recklessness in it to see if we could somehow get it shoehorned into a liability policy. Another tort, and I talk about this because I'm going to suggest that we're going to see in the next decade, or some of us will see in the next decade, maybe not me, the tort of defamation get played out again in the United States Supreme Court. So the tort of defamation, if it's a written defamation, it's libel, L-I-B-E-L, and if it's oral, it's often referred to as slander. And what is the tort of defamation? When someone or an entity makes a false statement of fact, not opinion, but fact about another person or entity that damages that person's reputation or the entity's reputation. And the controversial part, perhaps, is if the communication is made about a public figure or a matter of public interest, then there's United States Supreme Court decisions that say that those communications fall within the protection of the free speech provision of the First Amendment. And to recover, the plaintiff must not only establish the false statement in damages, but that the false statement was made with knowledge that it was false or reckless disregard for whether it was true or false. That's often a tough burden to get over. The second tort we could consider is products liability, and that is there's a consumer type of product, and it doesn't necessarily have to be a consumer type of product, but a product that has been sold for use. It might be a product that is used just in manufacturing, for example, as opposed to the lawnmower I bought last year at Home Depot. But in any event, if a product is being used in the manner intended by the manufacturer, so I'm mowing my small lawn, and the use of the product creates an injury, we could arguably have a claim for product liability if we could establish that there was some defect in the property, in the product that caused the harm without having to establish that the defect itself was brought about by negligence. And as I point out, the tort of products liability can be incredibly complex, and it's been my experience that just like medical malpractice, it's a specialized area of practice for attorneys who pursue such claims. Okay, so this will end this second screenshot video for weeks 9 to 10.